LAWsome by ConsultWebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.
Hello to all our LAWsome listeners. Today on our show, I'm excited to be talking with Bill Mitchell, founding partner of Cruiser, Mitchell, Novitz, Sanchez, Gaston, and Zimmett. For over 30 years, Bill's developed a reputation as a nationally retained counsel and deal maker related to the most complicated and high-dollar civil litigation matters. Bill's also an expert in litigation management, and he's actually co-authored the cutting-edge book on litigation management. He gives seminars and training to carriers, GCs, and risk managers, all on reducing legal and indemnity costs by 20%. Based on the concepts of the book, Bill consults with such entities to improve their processes and develop as well as their implementation strategies to reduce legal and indemnity spend. Today's topic is the power of early evaluation and negotiation to close cases effectively and efficiently. Welcome, Bill. Thanks for joining the show today.
Thank you, Tanner. I'm pleased to be here. Thank you.
So let's just jump right in. In a highly competitive industry such as the legal profession, law firms, they very well may struggle to position themselves for success. Often they say it's a dog-eat-dog world here in the legal space. But one important aspect to help your law firm grow is clearly an early evaluation of your cases. Would you agree with that?
Absolutely.
So how can an early evaluation help attorneys begin to identify some of the strengths, maybe even the weaknesses of their individual cases?
Well, if you don't mind, I'm going to give you kind of the watershed moment I had in my life as a lawyer that I think put it all together for me.
Please.
I don't like tell long stories, so I'll try to make a long story somewhat short, but it's a really good and important lesson. When I was a fourth or fifth year lawyer, which would take us back to about 1995-ish, I was trying to get my first client. And I'm taking this guy to lunch. I'm trying to take him to Braves games, etc. And he does not have much interest in me, which he probably shouldn't because I was a fifth year lawyer. And one day, he's an insurance executive. One day he calls me and he says, hey, we have this new program and it's actually a school district program. And we win every case because there's all these immunity defenses. So we win a lot of cases, but every case we have, the lawyer bills about $100,000 on them. We win them, but we're billing $100,000 on them. And he said, so we got this new case in. It's a sad case. It's a death case. That lawyer did an evaluation. The lawyer thinks it's a winner on summary judgment. And the budget is about $70,000 for this case. And then that lawyer had a conflict. So he called me and he said something very simple. Get rid of it quicker and cheaper, and you'll be my lawyer in the future. And you got to think, I had to rewire myself because I'm in a big firm and I have this annual hourly requirement. And our goal is to, bill as much as we can because that's how you make money in the legal industry. And so the stars aligned. I probably got a little lucky. I probably used an untapped skill set that I didn't really appreciate I had. And through letters, conversations, etc., using a lot more honey than vinegar, I literally was able to achieve a voluntary dismissal of that case. I billed $5,000 and the case was resolved for $0 in literally 6 weeks.
Wow.
So I go to my law firm at the point and then they're like, what are you thinking? We lost $65,000 on that case. And as I say to this day, 27 years later, that client has sent my firm millions. And that is the seed of the foundational, premise of my law firm and my philosophy and what we try to execute every day here.
Do you know how many cases you're signing from your marketing investment each month? If you want to diagnose the status of your firm's marketing efforts, then the LAWsome podcast has a gift for you. Discover the best and the most unique legal marketing solutions available today using the Decision-Making Handbook's free printable criteria. Claim your copy in the bio below. Very intriguing. And it's often those experiences there that, in the moment when your client or whoever it is you're dealing with, when they see that, they see the heart of it, that's ultimately what wins the long-term relationships and, as you've proven, the long-term business. So, going back to the evaluation of these cases, can you speak to ultimately, some tips on identifying strengths and weaknesses of cases. Anything for our listeners?
Absolutely. Well, okay. So I do, I do litigation management and negotiation seminars. And so the very first thing I tell everybody in my teachings is no case is the same. I don't care if you're doing 100 car wrecks with $50,000 in limits, or you're doing E&O or employment discrimination. Every case is different. And I have a little visual for you. It's a kaleidoscope, and someone gave it to me 20 years ago, and it's very symbolic. Every case is a kaleidoscope. Every case has different issues, different opportunities, different leverage points, in that it's fluid. And so the goal is, first of all, how do we get our arms around the case to see the good, the bad, and the ugly as quickly as possible? Sometimes we can get that information immediately, and we know 90% of what we need to know to figure out what we should do. Sometimes you have to do what I call targeted discovery. The old days, we would do discovery, interrogatories, requests for documents, depositions, and wait 6, 9, 12 months to finally say, here's what we should do. We love to complicate things as lawyers. Some cases are complicated. There's no question. Many aren't. Many are in our industry. If someone tells me off the cuff in a coffee room, hey, Bill, I got this case, ABC is going on, blah, 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 blah. Probably I can say, you know what, here's what I think you need to do, and here's probably the value of the case. Or here, you need to find these 2 pieces of information to know what the value of the case is. Because once you early evaluate the case, they usually don't get much better for the defendant, and you can hopefully focus on resolution rather than litigation. And only lawyers win in litigation most of the time, especially defense lawyers. The more the case goes on, the more we bill. But they don't get cheaper, and I don't think the cost of settlement, the value of the settlement, usually, it doesn't go down usually the longer the case goes. That's just my experience.
Bill, I'm curious from your experience in even counseling, training other lawyers in this topic, how many lawyers out there are neglecting to do just what you're doing and doing that early evaluation of their cases?
Well, I think a lot are. I think the industry is requiring it and requesting it, but they're trying to be more hands-on because they have to be. If I survey, when I do my litigation management seminar, I might have 100 claims people or HR risk managers in the room, and I ask them, what do you spend most of your time doing? These are seasoned people who are very talented at what they do. Many are lawyers, some aren't, and they will literally say, we spend most of our time babysitting lawyers, because they're hiring the wrong lawyers, which then requires them to keep on top of their lawyers and keep strategizing with their lawyers. And let's face it, if you're a claims person running 100 or 150 cases, you can't do that. You have to find really, really good panel counsel who do that for you. And it takes a mindset to think that way, and then it takes a skill set to execute it. And respectfully, I think 20% at best have the mindset, and maybe 10% have the skill set. And that's the issue. And we're in this industry, we'll talk about later, isn't measuring, training, and enforcing this philosophy. They give lip service to it, respectfully. I'm a little in politics at times. A lot of lip service, but not a lot of actual implementation of how we can do this. And that's why when I counsel, I tell carriers in big box, billion-dollar companies that have, you can guess who I'm referring to, that I can save you 10, probably 20% in legal fees and likely settlement, because you don't have your arms around in hiring the right team to implement this economy and efficiency concept.
Every year we make predictions about legal marketing trends that will affect hundreds of thousands of lawyers across the country. If you've been looking to reach new clients, stay informed, or gain a competitive advantage in your market area, this is your opportunity. Unlock the secrets of success with this exclusive PDF that reveals some of the top legal marketing trends in the industry today. Claim your copy in the bio below. I mean, we're speaking to the beginning, the early stages of these cases, but I'd like to shift here and move in more to the big piece of running a law practice, and obviously important for your clients, and that's resolving the case, closing the case,
Right.
and getting it behind you and continuing to move forward. I think you may say negotiation is a critical tool, an important skill set, if you will, for attorneys in this process and
Absolutely.
wrapping up cases. And it can make your law firm obviously much more efficient and cost effective if you have the right negotiation skill sets and formula in place. Obviously, getting it wrapped up, I mean, you're speaking to this, saving clients money, them seeing that value is a tremendous retention tool. It's a tremendous word of mouth and referral tool. And so, following that same vein, why do you feel it's so important to have negotiation strategies for each individual case, and maybe you can speak to some of those, at least the common ones?
Absolutely. A great question. So here's the reality. Again, I've probably now and I got my little litigation management book. It's free, but I've spoken on this book to, I'm guessing at least now over 5,000 claims people. Again, from GCs to HR people to insurance companies to TPAs. Every seminar I ask the same question. I look in the room of the people and say, in the last 2 years, raise your hand if you tried a case. Ask, how many of you tried more than one case? And here's the data. Less than 1% of all litigated matters go to trial. Now, if you're dealing with a State Farm, Progressive, Geico, there might be trying more than 1%, but it's probably a little more. If you're dealing with general liability, employment practices, E&O, it is under 1% significantly. If it's 0.5%, they're lucky. Meanwhile, 92% at least settle. So 1% go to trial, 92% settle, and then there's 7 or 8% that you might get out on a motion. So here's what I ask in my seminars. I start my seminar by this. If 92% of every case that you get is going to settle, when are you going to settle the case? After you A, do you hire counsel? B, if you hire counsel, do you settle it after they bill $5,000, $10,000, $25,000? 50, 100? When do you get the case in line to get it resolved? If you know 92% settle. Now there's naysayers. And I have guys who say, Bill, we do not want to be known as the entity that settles. We don't want to be known that. And I'm like, well, I get that, but what's your reality? How many cases do you try? And their answer is, well, probably less than 1%. I said, well, your reality is that you don't try cases, you settle cases. So do two things. One, and I give a seminar now on identifying the 1%. You want to identify them early. The old school was every case would prepare for trial, and after counsel billed 50, 60, 70 grand, then it was settled. Colossal waste of money. But if you want to have a reputation that you try cases, then you do two things. First of all, the cases that you know are going to settle or likely going to settle, and we know fairly early, you have a great deal maker running those cases and resolving them. In the 10% that you think, they may go to trial, you hire a great trial attorney, put him in the trial bucket and go try the cases. And that's the kind of the way to attack them. And then you try the cases so you get a reputation that you do try cases, but you're not paying crazy fees to settle 92% of them still. If that makes sense.
Hiring an outside marketing agency can take your firm's business truly to the next level. But having to compare and contrast different legal vendors out there can be a rather overwhelming and complicated process. So we'd like to help you with that. That's why we've created this free digital vendor checklist. It's going to give you the tools and, more importantly, the confidence needed to truly evaluate and vet the potential vendors out there. It's going to help you understand specifically their legal marketing expertise, team qualifications, what they can and cannot do, types of services they offer, and expectations of those services, proof of success, have they been there before, have they helped other similar law firms like yours, and arguably, more importantly, your digital ownership rights related to working with them and what you own or do not own. Claim your free printable checklist in the comments below. It does, and honestly, from my standpoint in hearing that, it's a game plan. It's having a strategy, and it's leveraging the strategy so that you can be confident in that. I think, and this may be a good question for you, Bill. I mean, how many firms are operating their business just subjectively, to some degree, may I even say on a whim, without following this protocol? Is that something you've seen common in the industry?
I think most are, because I think. And for a long time, Tanner, frankly, I'm kind of like this guy wandering the desert, screaming at the top of my lungs, this is the way to do it. This is the true value proposition. Other firms will follow if the industry demands that they do this way. And what I love doing, I started doing this book, and I get, and I have the naysayer saying, well, yeah, I've heard, that's fine, but I think it's hard in execution. So then what I started doing is I started sending out e-blasts of what I call the disruptive lawyers, stories from the disruptive lawyers. And so I send out, this thing probably has about 20 stories in it. Mm-hmm. And I tell e-blasts where I tell a recent negotiation story where we flipped a case and got a great deal. And I know what the naysayers think. The cynics are saying they got lucky. And then they see a next one next week, and they're like, they got lucky twice in a row. And then the third one, they might say, I think they're just lying. Then the fourth, fifth, sixth one, they're finally saying, I don't know if the guy's lucky or not, but maybe we should hire them.
There may be something to this.
And in conclusion on this point, the best case I love getting is when we're the second firm hired. Because usually the explanation is, well, yeah, you got a good result there, but that was a different judge, different plaintiff's lawyer, different facts. So that, your case was different. Well, 10 times a year, I'm the second firm hired. And when we flip a case and we settle it for 10 cents on the dollar because the first lawyer said it was impossible to settle and build 80 grand, and we walk in 3 months, settle for 25 grand. Same judge, same plaintiff, same plaintiff's counsel. And sometimes I go, well, that plaintiff's counsel was a moron. You got lucky. And my response is, well, the other lawyer A dealt with the moron for 6 months before I got involved. So again, I'm a guy in the desert screaming, but this is the value proposition. I think the industry is going that way. And I think my brethren on the defense side would be smart to go that way too, to show this value.
I'd love to tap into the experience a little bit and hopefully help our listeners here, especially those that are really resonating with this concept. Bill, you have 30 years of experience as a trial lawyer, and you've handled some of the more complicated and high dollar matters in the industry. What would you say, if we could offer maybe shed some light on the mistakes that you've observed or that you've learned from, what would you say are some of the more common mistakes that attorneys are making when they're evaluating and even negotiating these cases? How can they avoid them, and more importantly?
And I do speak, I won't tell you about it because I don't have time, but I just did a LinkedIn on it called the Jackass case. And I tell you people, nope, it's not about a hurt donkey. It's about me. I was a complete jackass and gave wrong advice because I didn't have the skill set, mindset, or, intestinal fortitude to steer a case that ultimately blew up on my client and I got fired. That was just before I got this other case in. It was probably 1994. So I have a lot of failures, and the keys you learn from failures. Here's what I would tell most lawyers. The very first thing I do in every case is I call the other side and say, what are we fighting about and what am I missing? You know this case. You've had it longer than me, more than likely. We just got it. Tell me about it. And I do it in a very inquisitive, non-confrontational, non-provocative way. Because I have learned, there have been times where I've written a report to a client saying, this is a BS case, there's no liability, we got them, they need to dismiss it. And then we're a few months in the case and they show me some piece of evidence or some archaic statute, and I literally have egg on my face because I was wrong. And so from those lessons, I now talk to the other side and they might say, Bill, no hubris. What's going on in this case? And they may say, well, you understand there's a statute. I know it's a 1948 statute and there's no case interpretation, but there's a statute that says your surveyor had a duty to do X. And I'm like, oh my, thank God you told me. That changed my complete evaluation. Didn't know about the 1942 statute. So you'll learn things. And if you have credibility with the other side, because sometimes the other side says, I'm not going to tell you my secrets. And the response is, most secrets are not gotchas. They're usually documents that everybody knows about or statutes that we should know about and you can't get around. So it's better to kind of lay the cards on the table early. And plaintiffs want to too. Plaintiffs are in the business of making money. They rather make X, dollars and work 10 to 20 to 30 hours on a case than X $0.5 and work 100 hours and make the money 2 years from now. They're all financial creatures, and so we need to use that leverage. Negotiations about leverage. One key leverage point is the quicker you get the plaintiff to the table, the more money they make and the more reasonable they're going to be. And on this last point, and if you have something that you got the plaintiff on, most of the time, I'm not saying all the time, a plaintiff's lawyer wants to know if they don't have a McMansion, they actually have a money pit. If you show the plaintiff, I know you think you have a great case and I know you're trusting your client, but do you understand in this EPL case that your client was the worst salesman for 5 years in a row? That's why he got fired. And we get as many dismissals without prejudice or walkaways than we've ever gotten, because we put our cards on the table and we say, man, you got a money pit. And if they don't walk away, they might say, you know what? I know we wanted $300,000, but we didn't know this stuff. We'll take 100, and then you negotiate and you get rid of it for 25 grand, which is still way under the cost of defense in the case.
Hey there. Perhaps most don't associate lawyers with the social media platform TikTok, but I would encourage you to think again if that's you. The reason being is TikTok is now the #1 most engaging social media platform on the market. It presents truly a lucrative opportunity for lawyers who know how to use it and use it effectively. If you're interested in leveraging TikTok for your law office, grab the free resource in the comments below. Bill, you haven't even said this, but what I hear screaming loudly is just the value and the power of humility. Humility as a lawyer and accepting that, yeah, you very well could have blind spots, especially in the beginning of the case. And what are you doing?
Did you talk to Dan, have you talked to my wife? I mean, is that where we're going? We're now doing the introspective.
Yeah, this is an intervention here.
I know you're teasing me, or you're just making a great point. Yeah, humility is important. I've had to work on it, but I've learned lessons. When you get popped in the nose, you get humility. I've been doing this for 30 years. So you learn humility from getting popped in the nose, and you learn it's more effective. I mean, I will call a plaintiff's lawyer and say things like, is this your cousin? You are an A+ lawyer. You take big cases, and I don't think this is a big case. So this must be your cousin, your sister-in-law. What's going on? You're a big-time lawyer. What are you doing, right? And you kind of disarm them. Come on, So you got to open up the communication. And if you don't communicate, your client loses, because then you work for 6, 9, 10 months on the case, bill whatever, and 92% of the time you're going to end up resolving it anyways. So when do you get to it? And again, I'm not saying settle out everything. The client defines what a win is. But our goal is to give them the good, the bad, the ugly as quickly as possible so they can make an informed business decision on what they want to do, and not me bill $100,000 in 18 months from now, they look at me and say, we could have settled this case for $70,000 and now we're looking at 200 and you built 100. So I'm going to pay $300,000. What are we doing?
Bill, these insights have been fantastic. I'm grateful for you, grateful for the time you shared with us. Is there any final advice or comments that you'd like to share with our listeners?
The only final advice or comment I would share is, we're still living, even though big law and all these carriers are in this, very technological Moneyball era, this industry is not playing Moneyball. I give my value proposition results to my clients every year, showing cost of case, life of case, value of case, cost of defense, and I give all the averages. And I'll say, what do you think? And they'll say, this is very impressive. And I say, well, how do I compare? And the answer always, 99% of the time, is we don't know. We don't extract this data, and no one gives us this data.
Interesting.
And so this industry is still we're in the dinosaur age where this industry is still talking about anecdotal stories to hire counsel versus real data, which is informative on who's really doing a good job and who may not be. So that's kind of my final thought in that regard.
Very, very interesting and also extremely helpful. And I would ask, for those that would like to reach out to you or contact you, Bill, what's the best way that they can do that?
Yeah, you can reach me at B.Mitchell, BMITCHELL at CMLawfirm.com. I'm in the middle of the Masters in Negotiation series, which is a 10-part free series. It's 30, 40 minutes. And we're starting the next one in April. So if you want to be a part of it, the feedback on it, the biggest compliment I got is a general counsel of 20 years said about a month ago, I was very skeptical, figured I'd listen to one, but I'm not going to listen to all 10. And the feedback was, I have learned things in this negotiation series that I didn't even know I didn't know.
Wow. Maybe
you pick up something.
What's the best way for someone to look into more information on that seminar?
Again, email me. I'll send you a link, or you can go into our website. I think it's www.cmlawfirm.com.
Thank you, Bill.
Tanner, thank you. I really enjoyed it. You're a good man.
LAWsome by ConsultWebs with Tanner Jones. For show notes, links, and info, go to consultwebs.com/podcast. Be sure to subscribe and leave us a review. Watch for the next LAWsome episode to discover more breakthrough insights to build a thriving law firm.